who wish to attend this hearing shall appear on the premises of the extraordinary chambers in the courts of Cambodia an hour before the date of the hearing. 2. All cameras, camcorders, tape recorders, and loudspeakers are prohibited inside the courtroom, except as otherwise ordered by the pre-trial chamber. All persons are prohibited from smoking, bringing food or drink inside the courtroom. 4. All weapons are prohibited inside the courtroom. 5. Cell phones may not be used inside the courtroom. This includes the use of cell phone cameras and audio recording by cell phone, which is strongly prohibited. 6. Moving, changing seats, or walking freely inside the courtroom without permission is not acceptable and strongly prohibited. All persons are prohibited from shouting or making loud sounds inside the courtroom. All persons shall communicate with the security staff of the ECCC if they need to enter or exit during the course of the hearing. 9. Persons under the age of 18 are not permitted to enter the courtroom. The President of the pretrial chamber may take direct action against those persons who breach these regulations or commit any illegal activity against the proceedings as a result of the actual acts or offences committed. President of the pretrial chamber, Prakum San.
Règlement ou commettrait toute activité illicite déroulant des actes ou délits ainsi commis.
The co-prosecutors are arriving.
Les co-procureurs entrent dans la salle.
Four reporters are allowed to enter the courtroom.
Les journalistes sont autorisés à pénétrer dans la salle.
The court, please stand.
Veuillez vous lever.
Please be seated.
Veuillez vous rasseoir.
Please, the reporters, leave the courtroom.
Je prierai les journalistes de bien vouloir quitter la salle d'audience.
In the name of the Cambodian people and the United Nations, today, the pre-trial chamber of the extraordinary chambers in the courts of Cambodia declares open
déclare ouvert
the hearing of the criminal case
relative
number 002
dossier de l'affaire
1909-2007 ECCC OCIJ PTC 16 dated 10 November 2008 in which the charged person
pour lequel la
Ieng Thirith alias Pierre, Cambodian nationality, female, born on the 10th of March 1932, living in the 5th Kache, Phnom Penh, Cambodia, residing before her arrest at number 47B, Street 21, Tunle Basak, Chomkamon, City of Cambodia.
municipalité de Phnom Penh.
Father's name Kion deceased, mother's name Ukpon deceased, husband's name Ieng Thirith, 4 children.
4 enfants.
Each charged
Est mise en examen
with crimes against humanity, crimes set out and punishable under Articles 5, 29 new and 39 new of the law on the establishment of the extraordinary chambers in the courts of Cambodia, dated 27 October 2004. Defense co-lawyer
les co-avocats
Mr. Pat
pour la
Persieng
défense sont maître Pat
and Miss
Persieng
Diana
et
Ellis.
maître Diana Ellis.
Lawyers for the
Les
civil
avocats
parties
pour les parties civiles
Mr. Hong Kum Suon,
maître
Lao,
Kim Soon,
Mr. Lao Chun Thi,
maître Lord Chun Thi,
Mr. Ni Chan Di,
maître Ni Chan Di,
Mr. Kung
maître
Pisay,
Kong Pisay,
Mr. Yong Phanet,
maître Yong Phanit,
Mr. Kum Main Ki,
maître Kem Ming Ki,
Miss Moj Sawanari,
maître Mok Sawanari,
Miss Sik Studzinski,
Studinsky,
Miss Martin Jackman,
maître Martin Jacques,
Mr. Philip Cannon,
maître Philippe Canon,
Mr. Pierre Olivier Sieur,
Pierre-Olivier Sûr,
Miss Elizabeth
maître
Rabesan Ratna,
Elisabeth Rabes,
Mr. Olivier Bahuy,
Olivier Barougne
and Mr. David Jackman.
et maître David Jacquemin.
The greffier are all the participants present at the hearing.
Pouvez-vous nous dire si tous les participants sont effectivement présents à l'audience?
Yes, all except Ms. Diana Ellis, sir.
Président, à l'exception de maître
Today's hearing comprising the following elements. Mr. Prakam San, President, Mr. Rowan Downing, Judge, Mr. Nathol, Judge, Ms. Captain Kala, who's Judge, Mr. Hudbuti, Judge, Mr. Pain Pizzali, Reserve Judge. Greffiers, Mr. Chun Sok Risay, Ms. Annie Mary Burns. Co-prosecutors, Mr. Sein Bun Kik, Deputy Co-prosecutors. Mr. Wang Song De Wai Destamael, Deputy Co-prosecutors.
sont Monsieur Seng Bun Kian et Monsieur de Ville de Desmaël.
Mrs. Ieng Thirith, please stand up.
Madame Ieng Thirith, veuillez vous lever.
What is your name?
Quel est votre nom?
Mrs. Ieng Thirith, my original name is Q Thirith, alias Pierre.
Q Thirith.
I am 77 years old
J'ai 70
and I am
ans.
Cambodian
Je suis
nationality.
de nationalité cambodgienne.
I was born in Sangkat number 5 Phnom Penh. And what is your occupation?
Au quartier Saint.
I am
Votre
a
profession,
English literature
professeur
professor.
de littérature anglaise.
Where did you live before you were arrested?
Résidence avant votre arrestation.
I lived at Court 5, Phnom Penh, Cambodia. And my husband's name Ieng Thirith. How many children have you got? We got 4 children.
Dans la rue 21 à Tonle Bassac. Quel est le nom de
Have you
votre
asked
mari?
any lawyers to
J'ai 4
help
enfants.
you?
Avez-vous demandé
Mrs.
l'assistance?
Ieng Thirith, we have lawyer Pat Persing and Miss Diana Ellis, but she is not here.
Nous avons maître Pat Siang et
I would like to inform you that if pursuant to Rule
Je vous informe,
21(1)(d)
le président, conformément
of the
à
internal
l'article
rules,
21(1)(d) du règlement intérieur,
you are presumed innocent
vous êtes présumé
as long as your guilt has not been established.
tant que votre culpabilité n'a
You
pas
have
été
the right
établie.
to be informed
Vous avez
of
le
any
droit
charges
à
brought
l'information
against
concernant
you.
toutes
You have the right to be defended by a lawyer of your choice, and you have the right to remain silent.
Et vous avez
Please
le
sit
droit de
down.
garder le silence. Veuillez vous rasseoir.
I would like to
Je
invite the
souhaite que maintenant
Judge Hoodworthy to read the report of examination,
au
please.
juge Petit de lire le
របាយការណ៍
rapport
ស្តីពីការត្រួតពិនិត្យសំណុំរឿង
Report of examination. 1. Proceedings. 2. Examination of the case by the co-rapporteurs.
examen du dossier par les co-rapporteurs.
1A. Introduction. Pursuant to Rule 7710 of the internal rules of the extraordinary chambers in the courts of Cambodia, internal rules, the president of the pretrial chamber has assigned Judges Hoodworthy and Rowan Downing to set out the details of the order of extension of the provisional detention issued by the co-investigating judges against
Rendu par les co-juges
which the present appeal is lodged, and
contre lequel
examine
le appel est interjeté,
the case file
et
number
d'examiner le dossier
002
002
19
19
09 2007 ECCC OCIJ
OCIJ
PTC 16.
entre parenthèses PTC
Identification of the charged person. Ieng Thirith, alias Pia, female, Cambodian, born on March 10, 1932, 5th Courtyard, Phnom Penh, Cambodia, residing before her arrest at number 47B, Street 21, Tonle Bassac, Chomkamon, City of Phnom Penh. Father's name Kyo On, deceased. Mother's name Okpon, deceased. Ieng Thirith is presented by defense co-lawyers Mr. Pat Persing and Ms. Diana Ellis. Charges. Ieng Thirith is charged with crimes against humanity, murder, extermination, imprisonment, persecution, and other inhumane acts, being crimes set out and punishable under Articles 5, 29 new, and 39 new of the law on the establishment of the extraordinary chambers in the courts of Cambodia, ECCC law. Purpose of this report. This report of the co-rapporteur set out the details of the decision appealed against and the facts at issue before this court. It is to assist those who are not parties to the proceedings understand the matters before the court. B. Co-investigating judge's order on extension of provisional detention. On the 11th of November 2008, the co-investigating judges issued an order extending provisional detention of Ieng Thirith, who had been then detained since the 14th of November 2007 for a period not exceeding 1 year, pursuant to Internal Rule 63 6A. The co-investigating judges found that the first criterion to order provisional detention mentioned in Rule 63(3)(a) is still met, as there are well-founded reasons to believe that the charged person committed the crimes with which she is charged. To reach this conclusion, they rely essentially on the analysis of the case file that was undertaken by the pretrial chamber when seized of the charged person's appeal against the initial order for provisional detention, whose conclusions have not been undermined by exculpatory evidence. The co-investigating judges found that there has been no change in circumstances since the pretrial chamber decided that provisional detention is a necessary measure to ensure the presence of the charged person during the proceedings, to protect her security, and to preserve public order. They thus considered that the three grounds set out in Internal Rule 63(3)(b) continue to be met. The co-investigating judges consider that detention for nearly 12 months is not excessive in view of the scope of the investigations, the complexity and gravity of the crimes of which the co-investigating judges are seized, and added that the exercise of the right to remain silent by the charged person, although recognized and undisputed, is not conducive to speedy proceedings. C. Ieng Thirith's appeal brief. On the 9th of December 2008, the co-lawyers for the charged person filed their appeal brief against the order of the co-investigating judges, in which they request the pretrial chamber to 1. Hold that the strict requirements of the extension of the charged person's detention are no longer met. 2. Quash the order extending the charged person's provisional detention for another year. And 3. Immediately release the charged person under conditions deemed appropriate by the pretrial chamber. They do so on the grounds that the decision of the co-investigating judges is not adequately reasoned, and the co-investigating judges have not conducted their investigation with due diligence. D. Co-prosecutor's response. The co-prosecutors submit in response that the appeal should be dismissed in its entirety, as the charged person has not demonstrated any material change in circumstances since she was originally detained upon order of the co-investigating judges. 2. Examination by the co-rapporteurs. A. Insufficiently reasoned decision. The co-lawyers submit the following. Given that the co-investigating judges 1. Failed to provide adequate reasoning for its allegations, 2. Provided incorrect information, relating to the alleged evidence against the charged person, and 3. Provided incorrect or inadequate information concerning the charged person's access to the case file. The extension order lacks sufficient reasoning in contravention of Rule 63(7) of the Internal Rules and the aforementioned general principle of law. This failure should lead to the quashing of the extension order.
Ces insuffisances doivent
The co-prosecutors submit that the extension order by the co-investigating judges is sufficiently and adequately reasoned. The co-investigating judges set out the legal grounds and facts taken into account before coming to their extension order and are not obliged to indicate a view on all the factors. Contrary to what the defense alleges, the extension order does not contain any incorrect information, and the appellant has indeed access to all elements of the case file through her lawyers. B. Diligence in the conduct of the investigation. The co-lawyers for the charged person submit that the co-investigating judges have not conducted their investigation with special diligence, as they have failed to gather any evidence supporting the charges mentioned in the introductory submission. During the year that the charged person has spent in detention, they argue that the diligence exercised by the co-investigating judges should be seen in light of the evidence gathered during the charged person's detention, not the scope of the investigation. The co-lawyers state that arguably the investigations cover a complex area of facts, but if the co-investigating judges have been unable to bring any incriminating evidence more than merely confirming that she was a minister of social action against her in this 1 year of detention, the complexity of scope of the investigations is not relevant, or at least an insufficient standard. They further argue that the extension order, by putting the blame for delay on the defense, thus infringes the right to remain silent. The co-prosecutors submit in response that the defense have not shown how the length of detention has prejudiced the charged person's case in such a manner as to prevent a fair trial and or to demonstrate how it can and of itself justify a reconsideration of detention. They further argue that the length of pretrial detention is reasonable given the gravity of the crimes charged, the complexity of the case, and the extent of ongoing investigations being carried out by the co-investigating judges. The co-prosecutors also submit that the alleged infringement of the charged person's right to remain silent appears to be based on an erroneous reading of the extension order, and the right to remain silent is recognized and undisputed by the co-investigating judges. However, the absence of cooperation of the charged person does not assist the co-investigating judges in discovering exculpatory evidence. C. Well-founded reasons to believe that the charged person may have committed the crime or crimes specified in the introductory submission, Internal Rule 63(3)(a). The co-prosecutors submit that the principal issue in the determination of the appeal against an extension order is whether the conditions set out in Rule 63(3) are still met. They further submit that, considering that the pretrial chamber can undertake its own analysis and cure any defect in the order by substituting its own reasons, most of the arguments raised by the charged person in her appeal are of no material relevance. The co-prosecutors point out that the defense does not challenge the existence of a well-founded reason to believe that the charged person may have committed the crimes specified in the introductory submission. In their views, the pretrial chamber's finding that the condition set out in Internal Rule 63.3a is met has been reinforced by new evidence gathered since the decision was issued. The consideration of the grounds making provisional detention a necessary measure. Internal Rule 63.3b. The co-lawyers submit that the co-investigating judges failed to provide any reasoning or evidence for their conclusion that there is a real risk that witnesses might refuse to take part in proceedings if the charged person were released. They state that the initial standard of proof is no longer sufficient after 1 year in pretrial detention. The co-prosecutors respond that the charged person does not identify any material change of circumstances to show that conditions necessitating her detention under Rule 63.3b are no longer met, and does not contest that 4 of the 5 alternative conditions are met. The co-prosecutors submit that the offensive attitude of the charged person at the pretrial chamber hearings of the 21st of May 2008 and 9th of July 2008, consisting in threats and attempts to intimidate the parties and/or the judges, and should be taken into account when considering the risks to witnesses and victims and the personal security of the charged person under Rule 63b, 4 and 5. The co-prosecutors further state that the recent statements and behavior of some victims or civil parties show that any release of the 5 charged persons might degenerate into violence directed against the former Khmer Rouge leaders, including the charged person and defense teams or the ECCC. Phnom Penh, 19 of February 2009, co-rapporteurs Judge Woodwitty and Judge Rowan Downing.
The charged person, Ms. Ieng Thirith, please stand up.
Do you want to
Would you like to make a statement related to your appeal, or you would like your co-lawyer to speak on your behalf?
Mrs. Ieng Thirith, I'm too weak and I would like my lawyer to talk on my behalf.
Now, I would like to invite the defense co-lawyer to respond. You have 1 hour to make your brief statement.
Your Honor, the pre-trial chamber and all participants. I am Pat Persiam, the co-lawyer for Mrs. Ieng Thirith. Before making my submission, I would like your leave to allow my client to sit behind us so that she can feel comfortable, because when she feels weak, then she is close to us. Next, I would like to respectfully submit the following 13 points in my submission, and I will be elaborating the detailed items in sequential order. First, introduction. The co-defense lawyer do not intend to repeat the arguments we have already submitted in the appeal brief. However, we will be trying to explain some clarification in the following, and also to respond to the arguments in the response of the co-prosecutors. The co-defense lawyers are not intending to discuss any evidence in the extension order, or object or challenge any incorrect references as such. And the discussion on the substance of the evidence, and that we would like the pre-trial chamber to conduct the hearing in a closed session. However, it is not the right time to discuss the well-founded reasons shown by the co-investigating judges, who have only based their arguments on the responses of the charged person. So the defense is going to only focus on the legal arguments in our appeal brief, and we will discuss on the facts only if requested by the pre-trial chamber. These arguments will address the following topics: A, the nature and scope of the appellate review procedure; B, the requirements of Rule 67.3 of the internal rules regarding the reasoning of a decision; C, the no material change of circumstances required as pleaded by the co-prosecutors; D, the special diligence requirement; E, the relevance of jurisprudence of the European Court of Human Rights, which is of particular relevance to these proceedings; F, the unreasonable length of the period of pretrial detention; G, the lack of evidence brought forward against the charged person; H, the co-prosecutors' unwarranted interpretation of the charged person's behavior; I, the behavior of certain victims; J, the charged person's right to remain silent and not actively cooperate with the investigations against her; and K, the possibility of house arrest or release on bail, which would provide the same guarantees as provisional detention, but would be less intrusive to the well-being of the charged person. The primary contention of the defense is that the extension of the pretrial detention period is no longer legitimate, given the failure by the Office of the Co-Investigating Judges to exercise special diligence in their investigations into the crimes allegedly committed by the charged person. The defense submits that the evidence contained in the case file shows that the charged person was Minister of Social Action during the relevant period, as identified in the indictment. Such evidence was placed in the case file prior to her arrest, and no other significant evidence has been added to the case file during the period of her detention from November 2007 to the present time. The Office of the Co-Investigating Judges have had more than 1 year and 3 months to assemble evidence in support of the charges. At that time, they have failed to produce any evidence which directly links the charged person to the crimes committed during the relevant time. In the absence of such evidence, the threshold requirement for prolonged pretrial detention is no longer met. The nature and scope of appellate review. The pretrial chamber's role is to scrutinize and monitor the OCIJ's investigations in order to safeguard the rights of the charged person. In paragraph 5 of its response, the co-prosecutors allege that it is irrelevant whether the OCIJ makes errors of law and or fact in its decision, because the pretrial chamber can still undertake its own analysis and cure the defects by substituting its own reasons. This argument would render the meaning of Rule 63(7) at the level of the co-investigating judges pointless. This rule, however, applies to all levels of the judiciary, including the OCIJ, and under the terms of Rule 63(7), the decision shall be in writing and shall set out the reasons for an extension of provisional detention and are thus mandatory, and any breach is subject to the scrutiny of the pretrial chamber. The defense submits that it is relevant that the co-investigating judges have made numerous errors of fact and law in their order, and accordingly it should be quashed by the pretrial chamber. Insufficient reasoning of decision. Rule 63(7) of the internal rules provides that any decision by the co-investigating judges concerning extension of provisional detention shall be in writing and shall set out the reasons for such extension. The defense submits that this provision has been violated on several occasions. On several occasions throughout the extension order, the OCIJ failed to provide adequate reasoning for its allegations and provided incorrect information relating to alleged evidence against the charged person. The extension order lacks sufficient reasoning in contravention of Rule 63(7) of the internal rules and the aforementioned general principle of law. This failure should lead to the quashing of the extension order.
Et
Firstly, the prosecution has misinterpreted Rule 63 in paragraph 8 of its response, where it states that the OCIJ is only required to set out the legal grounds and facts taken into account, and that referring to the case file in general and other circumstances is sufficient. Rule 63(7) clearly requires that the OCIJ to refer to the evidence upon which it bases its decision. What is required, in line with the jurisprudence from many other jurisdictions, is a reasoned decision. Given that the law explicitly requires the decision to be reasoned, general references to the case file do not suffice, as they lack of specificity. The prosecution denies that the extension order contains any mistakes. Response paragraph 9, but nonetheless attempts to provide references to evidence where the extension order lacks reasoning. No material change of circumstances required. The co-prosecutors state in paragraphs 13 and 45 of their response that the situation of the charged person should be compared to the situation of defendants before the ICC, ICTY, and SCSL, where the defendant must demonstrate a material change of circumstances. What the prosecutors fail to mention is that the presumption at the ECCC is release and not detention, as mentioned in Article 203 of the Cambodian Criminal Procedural Code, and Rule 63(3) of the Internal Rule provides that the co-investigating judges may order the provisional detention of the charged person only where the following conditions are met. Rule 82(1) of the Internal Rules provides that the accused shall remain at liberty whilst appearing before the chamber unless provisional detention has been ordered in accordance with these Internal Rules, which clearly suggests a presumption of liberty. Article 9(3) of the ICCPR, which was ratified by Cambodia on the 26th of August 1992, states, "It shall not be a general rule that persons awaiting trial shall be detained in custody, but release may be subject to guarantees to appear for trial." The standard which governs the pretrial detention proceedings at the other tribunals is thus not applicable to the ECCC. The OCIJ needs to prove that there is a basis for further incarceration at this stage of the proceedings, and there is not on the defense. This is not a responsibility of the defense. The defense do not need to show a material change of circumstances as suggested by the co-prosecutors. In any event, the prolonged nature of the investigatory stage has caused the charged person to undergo a considerable period of detention to date, and this may, without more, constitute of itself a material change of circumstances. Special diligence standard. In the extension order, the OCIJ employed the standard of due diligence in determining whether it complies with a process within a reasonable time period. The OCIJ is required to make sure that its investigations are done in an adequate way. And the defense argued that the appropriate standard is not of due diligence as applied by the OCIJ, but a higher standard of special diligence as set out on many occasions by the European Court of Human Rights. In paragraph 17 of the English original version of its response, the co-prosecutors erroneously and without foundation allege that the defense refers to a standard of absolute diligence. And the defense did not use this term, nor did it imply such an unattainable standard. It is admitted that the OCIJ have incorrectly applied the lower standard of due diligence instead of special diligence. With regard to the application of the appropriate standard, the co-prosecutors in footnote 76 concedes that indeed the pace of the investigations has not been optimized during the first year of the charged person's incarceration, where they state that now that the closing order has been issued in case file number 1, it is expected that the pace of investigations will drastically accelerate in the near future. Relevance of European Court of Human Rights jurisprudence. The co-prosecutors deny any applicability of European Court of Human Rights jurisprudence in determining whether the investigations exceed a reasonable period of time. They suggest that rather than looking at the European Court for guidance, the ICTY and ICTR should provide such assistance. This neglects the fact that both the ICTY and the ICTR have on many occasions taken the case law of the European Court as guidance in human rights matters relevant to the proceedings, as did the ICC and the Special Court for Sierra Leone. There is no basis upon which the co-prosecutors can conclude that guidance in this area cannot be sought from the judgments, meaning from the European Court of Human Rights. The defense submits that case law of the ICTY and ICTR is less relevant to this specific issue, is that pretrial detention at the ad hoc tribunals is governed by different rules. Pretrial detention at the ad hoc tribunals is the principle and release is the exception. The whole legislative framework of the ECCC is based on the presumption that the charged person will be provisionally released and that the OCIJ must justify provisional detention. It is thus fundamentally different from the policy of the several ad hoc tribunals. Further, the ICTY and ICTR systems are based on common law rather than civil law. The ECCC is based on a civil law system. The European Court jurisprudence cited by the defense in its appeal all relates to countries with a principally civil law system, for example, France, Germany, and Austria. The defense thus contends that reliance on the said jurisprudence is justified and relevant to the matters in issue and will provide helpful guidance for the pretrial chamber. At paragraph 17 of its response, the OCP complains that the defense would pick and choose from the European Court case law in order to justify the applicability of the said special diligence standard. To the extent that the OCP may have been thought to imply that there is an alternative standard which has been advanced on other occasions, The defense does not know of any case where a lesser standard has been relied upon. Furthermore, the OCP has failed to cite any case law to demonstrate that the European Court has on any occasion applied a different standard. It is admitted that the European Court has used this standard of diligence consistently in all its cases involving the length of pretrial detention and not merely in certain jurisprudence as alleged by the OCP. Paragraphs 18 and 19 of their response, the co-prosecutors outlined that the European Court jurisprudence is irrelevant because of the fundamentally different nature of the European Court and the ECCC. The nature of these two institutions is different, but the European Court sets the minimum human rights standards its member states should adhere to. This is a minimum standard which we submit and should be taken into account by an internationalized tribunal such as the ECCC. And especially in a situation where complex international crimes are under investigation, and it is vital to ensure that the rights of the accused persons are protected. The OCP at paragraph 19 asserts that the case of the charged person is more complicated than cases brought before the European Court. In fact, many national jurisdictions deal with international crimes, including war crimes and other complex and grave criminal cases, all of which may be subject to the European Court's scrutiny. The defense submits that the jurisprudence of the European Court cited in this appeal is thus relevant and can provide helpful guidance for this court. Unreasonable length of pre-trial detention. In paragraph 26 of its response, the co-prosecutors imply that the fact that Rule 63 of the internal rules provides for a maximum of 3 years in pre-trial detention proves that any detention period below 3 years must be reasonable. This position is self-evidently erroneous. Where the liberty of the individual is threatened, all societies which adhere to the rule of law provide a benchmark against which to determine the propriety of denying the individual his or her liberty. The test of special diligence provides a safeguard to ensure that any period of pretrial detention does not become unreasonable. The OCP implies in paragraphs 18 and 28 that the charge of joint criminal enterprise as a form of liability has complicated the proceedings. The logic of this is not obvious and should not be used as a justification for a prolonged period of pretrial detention. There are a number of references by the OCP. See paragraphs 22, 27, and 28 of its response, to the effect that the charged person's 1 year in provisional detention is not unreasonable. That period of detention is not the subject matter of this appeal. It is the extension thereof beyond that 1 year which the defense argues is no longer reasonable in all the circumstances and given the lack of performance by the investigating authorities during the initial period of detention. Lack of evidence. In paragraph 39, the OCP fails to provide any factual basis by references to the case file for its stated belief that the evidence against the charged persons has increased both in volume and gravity in the recent months. The OCIJ have concentrated their investigations on finding evidence in case file 001 during the first year of the charged person's detention and have failed to provide direct evidence against the charged person. In this regard, and as mentioned before, the co-prosecutors explicitly state in footnote 76 of their response that now that the closing order has been issued in case file number 1, it is expected that the pace of investigations will drastically accelerate in the near future, thus concerning that the pace has not been at full speed until now. In paragraph 29, the co-prosecutors assert that the evidence collected by the OCIJ covers all the modes and types of the appellant's contribution to the crimes against humanity she is charged with, including crimes-based evidence, evidence linking crime based to leadership structures within which the appellant exercised command authority, evidence supporting her participation in the joint criminal enterprise, evidence supporting jurisdictional elements such as the widespread and systematic attack against a civilian population, and so forth. Like the OCIJ, the co-prosecutors failed to provide any sources to support such a statement. If this were indeed the case will be ready for trial very soon. The Office of Co-Investigating Judges clearly concentrated on gathering evidence in the Dutch case and failed to collect direct evidence against the charged person, thus demonstrating a lack of special diligence in the conduct of the case of the charged person in case file 002. The pre-trial chamber ruled on an earlier occasion that the OCIJ order to provisionally detain the charged person was justified. The defense cannot seek to go behind the underlying reasons of that earlier decision. The defense submits that the OCIJ did not meet the appropriate threshold by failing to provide direct evidence against the charged person during the year in which she has been in provisional detention. The longer the provisional detention is continued, the higher the threshold becomes for the OCIJ to put evidence on the case file. Now that 1 year has lapsed, the threshold has become higher, and the OCIJ needs to provide direct evidence against her. The OCIJ is unable to do so, and the evidence it did find in relation to the charged person relates solely to the fact that she was a minister of social action during the regime, which does not relate to the crimes she is charged with. Interpretation of charged person's behavior. The co-prosecutors assert in paragraph 47 that the fact that the charged person may speak out on her innocence, as she did during the previous hearing, may affect her security once released. The defense contends that there is no sensible basis for this hypothetical concern. The question is, would the provisional release of the charged person pose a real risk to witnesses, the preservation of evidence and the public order. The co-prosecutors wrongly and inappropriately seek to rely, see paragraph 47, on the charged person conduct at an earlier hearing. The court is respectfully invited to put out of its mind as irrelevant the matters adverse to by the OCP. Victims' threats against Nuon Chea and Khieu Samphan. The court is respectfully invited to put to one side the matters referred to in paragraph 52 of the response of the OCP as irrelevant to the determination of the issues in the case. The charged person lived and traveled extensively in Cambodia throughout the years preceding her incarceration without any incidents affecting her security. The OCP response refers to an article written by Rob Savage, footnote 108, and the defense addressed the failings of the article in its brief dated. There is no basis upon which the court could treat the article as an authoritative document. The court is reminded of the presumption of innocence. Further, there is no evidence that victims of violence have thought to act unlawfully against the alleged perpetrators. Right to remain silent and not to cooperate in the proceedings. And the defense objections to the co-investigating judges' intention to extend Madame Ieng's provisional detention of 27 October 2008, the defense indicated that the defense has not requested any investigative action